Hi everyone, this is Murmi Fukan. Today I am going to discuss about restructuring of bonds in the context of COVID-19, the pandemic. As you all know, the COVID-19 pandemic has forced the regulators like SEBI, RBI to come out with various relaxations as regards the stringent compliance provisions on various matters. One such relaxation brought in by RBI was to allow 3 months moratorium period by the banks and NBFCs on loan servicing and working capital facilities. Following the same footsteps of RBI, SEBI also brought two circulars addressing mutual funds and credit rating agencies, whereby credit rating agencies and mutual funds were advised to not to consider rescheduling in payment of debt obligations, including payment of principal and interest, as a case of default if such rescheduling is solely caused by the pandemic. Default in generic terms is a credit event, mostly analogously referred to as failure to pay. Under the credit rating guidelines issued by SEBI, the term debt obligations refers to an obligation to repay a debt on a scheduled repayment date, failing which the same will be treated as a default. Therefore, if the payment is not required to be made as per the contractual terms between the borrower and the lender in the first place, then the same is not a case of debt obligation. The laws in India provide for various remedies to the debenture holders in case of default. Such options are broadly insolvency proceedings, enforcement of security interest, proceedings for recovery of debt due. Under Companies Act 2013, Rule 18 of the Companies Share Capital and Debenture Rules provides the debenture trustee a right to call a meeting of all the debenture holders on the requisition in writing, signed by the debenture holders holding at least one-tenth in value of the outstanding debentures at any point of time, or on the happening of any such event which constitutes a breach or default, or which, in the opinion of the debenture trustee, affects the interest of the debenture holders. Similar provisions are there in the SEBI debenture trustee regulations also. Additionally, subsection 10 of section 71 of the Companies Act 2013 also provides a right to the debenture holders to move an application with NCLT seeking redemption of the debentures forthwith on payment of principal or interest in case of failure of the company to redeem the debentures on the date of their maturity, or failure to pay the interest on the debentures when it is due. Under IBC also, debenture holders, being a financial creditor, may exercise all the rights as available to a financial creditor. Accordingly, the debenture holders, whether secured or unsecured, may apply for initiation of corporate insolvency resolution process against the company under Section 7 of IBC. As clarified by the central government, such right may also be exercised by the debenture holder through a debenture trustee. Another right available to the debenture holders is to enforce security interest. The right of foreclosure is a counterpart of the right of redemption. Just like a company has a right of redeeming the security after payment of debt amount, a secured debenture holder has also a right of foreclosure or sale in case of default in redemption. There are various judicial decisions in this regard, such as Baroda Rayons Corporation Limited versus ICICI Limited and the Canara Bank versus Apple Finance Limited, wherein the Bombay High Court upheld the right of the debenture trustee to sell off the properties of the company for the benefit of the debenture holders. However, exercising of the right of foreclosure shall depend on various factors, as the law distinguishes between the security interest based on the nature of the collateral. For instance, in case of security interest on immovable properties, then Transfer Properties Act shall apply. Further, the security interest in case of a secured debentures can be enforced in different manner based on the type of the holder of debentures, such as enforcement in case of debenture holder is a bank or financial institution, then the proceeding then such bank or financial institution shall proceed with the provisions of SARFAESI Act. And in case of debenture holder is not a bank or financial institution, the enforcement shall be as per the common law procedures. Apart from the Companies Act, IBC and SARFAESI, since any default in the terms of debentures is a breach of contract, the debenture holders may sue the company for the breach of contract as per the provisions of Contract Act 1872. Further, they may seek for compensation as per the terms of debenture. Coming back to the topic, in the context of COVID pandemic, the restructuring of debenture shall mean actually nothing but deferral of the date of redemption as earlier agreed to by the parties. Therefore, before going to the legal requirements, one has to refer to the terms of debentures, which provides the various terms including redemption and the manner through which any variation in terms can be effectuated. Therefore, it is always necessary to consider the relevant clauses in the issuance terms. From the legal requirements point of view, in terms of Regulation 59, Subregulation 2 of SEBI LODR Regulations 2015, any material modification to the structure of debentures in terms of coupon rate or redemption, etc., are required to be approved by the Board of Directors and the debenture trustee. Further, in terms of the said regulation, prior approval of the stock exchange shall also be required for such modification in the terms. As mentioned earlier, DT may also call a meeting of the debenture holders on the happening of events affecting their rights or on the requisition of debenture holders, as provided in the SEBI DT regulations and the share capital and debenture rules. Though, unlike the requirements of obtaining shareholders' consent by way of a special or ordinary resolution for various matters, there is no such explicit provisions for obtaining of a consent of the debenture holders for restructuring of debentures under CA 13, Companies Act 2013. However, the provisions of Section 118 and SS2 being mutatis mutandis applicable to a meeting of the debenture holders also, all the provisions with respect to convening and conducting of general meeting, such as sending of notices, explanatory statement, appointment of proxies, etc., as applicable to general meetings shall also apply to the meetings of debenture holders. Accordingly, the majority of debenture holders may approve the restructuring of the terms. Looking at the current crisis situation where calling of a physical meeting is not possible, MC also recognized the video conferencing mode as a mode to conduct meetings of shareholders. Accordingly, the meeting of debenture holders may also be held through such VC mode. The modalities for participation like voting, two-way communication, recording, etc., and other compliances related to sending of notices, etc., may be in the manner clarified by the MCA circular. As regards the documentation part involved in such restructuring, in usual circumstances, if any variation is carried out in the debenture terms, the parties enter into an addendum amending the clauses contained in the debenture subscription agreement and also in the trust deed or security documents wherever it is applicable. However, given the current scenario and the lockdown situation, it is not possible for parties to sign and execute the agreements since the restructuring already has the approval of majority debenture holders. It is deemed that the resolution overrides the terms of issue. Therefore, it seems that the resolution passed by the debenture holders approving the restructuring should suffice and the modification in the agreement may not be required. Thank you.